Hello, and welcome back to another episode of Elder Law Advocacy, the conversation, where we dive into real stories and legal issues that impact older adults and their families today with the experts who are making a difference. Today we have attorney Alan Azevedo-McCaffrey with us. Did I pronounce that correctly?
Yeah, Azevedo-McCaffrey.
Good enough.
Yeah, good. Yeah.
Azevedo-McCaffrey. Okay. We're going to talk about a lot of things. Alan has been an attorney for 5 years and has been with Elder Law Advocacy for about 1 year, a little over a year. And he works primarily on cases in Imperial County in California. So we're going to be talking about what it's like to work in rural California, what's unique about Imperial County and the people who are coming to Elder Law Advocacy, and just what it's like to be an attorney with Elder Law Advocacy. So welcome, Alan. Thank you for joining me today.
No problem.
I think we're going to start with just a little bit about you. So can you just tell us a little bit about your background, what you were doing before you became an attorney, why you wanted to become attorney, and how you ended up with Elder Law Advocacy?
Yeah. So I'm from San Diego, born and raised here. I went to UC San Diego for my undergrad. I studied political science and history, and social sciences and history were always my favorite subjects in school. So I thought a good way to utilize what I'm interested in and the skill set that I had from um, my education was to go to law school. And, I was a big reader in college and high school. So my favorite books were Invisible Man and To Kill a Mockingbird. And some of the protagonists in those books were attorneys that were doing good things. And I thought it would be a good career to pursue.
What is Invisible Man? I'm familiar with To Kill a Mockingbird, but I haven't read Invisible Man. What is that?
Invisible Man is a book by Ralph Ellison that touches on um, race and justice issues
Oh,
in the United States.
is it fiction, historical fiction, or is it?
It's a fiction book.
Okay,
Yeah, definitely check it out. It's not The Invisible Man, it's just Invisible Man.
Invisible Man. Okay, great. And so that was kind of what prompted you to think about law.
Yeah.
And then did you go to law school right out of undergrad? And what were you thinking at that point?
No, so my very first job out of college was working at St. Augustine High School. I worked as a roller hockey coach and a
Cool.
substitute teacher. And so I did that for about a year. And then I started working at a local law firm as a file clerk. Um, I later decided I wanted to try something, a new city out. So I moved to Seattle actually. And I got a job as a file clerk at another law firm there, a big insurance defense firm. And they were a very old school type firm. They had a huge filing room. It was
Mm-hmm.
bigger than any office we have here at Elder Law Advocacy. Um, and that's what I did for about a year. Um, I think I got really good at it. I think I was the best file clerk in Seattle that year. And I loved Seattle. I loved living there. I made a lot of good friends and I decided to go to law school there. So I went to Seattle University School of Law. And that was a great experience because they um, really emphasize social advocacy and using your law degree to try to help underserved populations and people. So I got involved with a lot of the legal clinics there. I interned at the Northwest Justice Project, which is one of the biggest um, legal aid organizations in the Northwest. And I learned a lot and decided I wanted to pursue a law career that emphasized that as well.
Okay.
Yeah.
And so how did you end up at Elder Law Advocacy?
Well, Prior to working here, I had worked at another legal aid organization called Housing and Economic Rights Advocates, where I was working with their estate planning team, helping people make um, um, estate plans, including revocable living trusts, advanced healthcare directives, and um, last wills and testaments. And I really enjoyed that job, but I decided I kind of wanted to just explore other areas of the law. And just doing some research, I actually found the Elder Law and Advocacy website.
Hmm.
And I thought you guys weren't hiring at the time, but I had never heard of the organization. And I thought it just seemed like a very interesting place to work that was tackling issues in a in a different way. And I later saw that you guys were hiring, and I applied, and you contacted me when I was on vacation
I remember.
in Europe. So I've been happy here ever since.
Let's talk a little bit about what it's like to practice law in Southern California and more specifically in Imperial County. So why don't you first, you do practice primarily in Imperial County.
Yeah.
Tell me what Imperial County is and where it is and what's unique about it.
Okay. Yeah. So I'm not from Imperial County, but like you've mentioned, most of my cases um, are originate from there. So Imperial County is the most southern and eastern county in California. It's the newest, the youngest county in California, created in 1907. To the west, you have San Diego County. To the north, you have Riverside County. To the east, you have Arizona. And below it, you have Mexico.
Mhm.
The biggest city to the south in Mexico is a city called Mexicali. So I believe in around 2020, per the census, the population of Imperial County was a little under 200,000 people. Although it's a desert where you have temperatures as high as 115 degrees, maybe more in the summer, its economy is agricultural.
Mm-hmm.
That's primarily due to irrigation systems. 85% of the population is Hispanic. There's a large, only Spanish speaking population in Imperial County as well. And what else I could say about it? Well, it's a strong community. It's very unique, I think. It's the people that are from there. I can tell they're very proud of where they come from. And there's a lot of people working there trying to improve the lives and the quality of life for older adults.
Mm-hmm. Interesting. And so tell me a little bit about the kinds of cases that you see in Imperial County and if there's anything that's unique about practicing law there.
Yeah, so I guess I would say that the types of legal issues that people in Imperial County have versus San Diego County aren't so different. People there, they need power of attorney documents, they need advanced healthcare directives, they have disputes with their neighbors or maybe a contract issue, just like people here in San Diego have. One thing that I've noted that is different is that in Imperial County, there's far less resources available to people than San Diego County. So when you're trying to address large systemic issues such as the justice gap, particularly among older adults here in the United States, people who have far lower incomes, it requires an interdisciplinary and multi-organizational effort
Mm-hmm.
to properly serve the population. And there's a lot of good organizations and a lot of really hardworking people in Imperial County trying to address these issues and trying to serve the older adult population. But there's just, the fact of the matter is that there's just less options for people to pursue or choose from in Imperial County versus San Diego County. So
Right.
it creates an inequity.
Yeah. Is adult protective services available in Imperial County?
Yes.
Okay.
Yeah.
So the same type of services that they perform here, they perform in Imperial County?
Yeah.
Okay. Do you know, we have legal aid, a massive legal aid organization in San Diego. Is there anything like that in Imperial County?
Well, you have us,
Yeah,
right?
we have us.
You have Elder Law Advocacy.
Mm-hmm.
And then you also have CRLA, California Rural Legal Assistance. Yeah. But besides these two organizations, there's just not a lot of other options available to people, unfortunately.
Mm-hmm.
And there's far less expertise.
Right.
You know, here in San Diego, you have a lot of organizations, and a lot of these organizations, they work together, they know each other, and they know who's an expert in what. And because there's just far fewer resources available in Imperial County, that also means there's less expertise. So if someone has a very specific issue, they may not be able to get help as readily.
Right. So what kinds of issues do you see? What are some common cases? And is there anything that you might not see if you're in San Diego that you do see in Imperial County?
Well, one thing just to appreciate is just the fact that Imperial County is a much more rural area than San Diego County. So, you know, whenever you're doing a legal analysis, the facts are so important, right? And you do just end up with scenarios, with cases in Imperial County that I think are less common than in San Diego. You know, people, if they own land, maybe the land is, you know, bigger and it's more easy to get trespassers on your land, you know, versus in San Diego County where everyone has a fence, right? But, you know, we get a lot of, we get a wide variety of cases in Imperial County. And I think that's why, one of the reasons why I really like this job. No day is boring, and we're learning every day. We get a lot of calls about people wanting to know more about power of attorney documents or advanced healthcare directives. We get a lot of calls about housing security, wanting to know their rights if their landlord is threatening an eviction or if they receive a notice ending their tenancy. And we get questions about elder abuse as well. So there's a wide variety. I would, you know, I encourage anyone to call us. You know, if you're 60 and up in Imperial County and you have a question, if something doesn't feel right, something doesn't feel fair, just give us a call and we can talk to you about your issue and try to help you figure out what's going on. And if we can't help you directly, we'll try to steer you in the right path to get you to where you need to be.
Great. Thank you for mentioning that. What kind of, you mentioned elder abuse cases. What kind of elder abuse cases do you see?
How do you mean?
What are they scams? Are they people they know who are physically abusing them or financially abusing them? What kind of cases do you see?
Well, I guess I would say all the above.
Okay.
Unfortunately. We see, we get people who come to us who may be in situations where maybe they have a roommate, someone who is a family member or a friend, someone who's younger than them, who is physically abusive, verbally abusive. We have people who have problems with their neighbors or even a landlord who is being verbally or sometimes even physically abusive. And we also get a lot of people who come to us who feel like they were wronged contractually. People who got into a consumer situation, maybe they didn't understand what was happening when they were trying to purchase something. They felt rushed by the salesperson, and then they walk out having bought something very expensive that they didn't intend to buy.
Ah.
So that's very common as
What
well.
can you do in a situation like that?
Well, I would say if you are in a situation where you're speaking to a salesperson, and if you're confused about anything, just realize you don't have to buy this thing right now. Stop. A lot of times people, they come to us and, they'll describe a very common scenario. They went to go, ask a question about a product. Maybe they went to go have their car serviced somewhere. They saw a sign advertising, um, a new product,
Mm-hmm.
and they go into this store and they get distracted by a salesperson. Salesperson offers some kind of deal, sits them down, gives them a lot of paperwork in a language that they don't understand.
Mm.
Maybe they're speaking Spanish with this salesperson and they only know Spanish, but all the paperwork is in English and the salesperson's telling them to sign here, sign there. And when they leave, that's when they realize they purchased something they didn't intend to buy.
Mm-hmm.
The situation that they describe is always confusion, right? They don't in the moment that they purchased this thing unintentionally, they didn't know what was happening, and that's all by design,
Mm-hmm, of
by the
course.
salesperson, right?
Right.
So just understand, if you're confused about any kind of transaction, just take a beat, pause, go home, and think about what happened. Review the paperwork, have a friend or a family member, or you can bring it to Elder Law Advocacy and we can help you review it. So just take a beat.
Yeah.
Yeah.
I think we've all been in that situation where we're contemplating some kind of purchase and a salesperson is interacting with us and they have some very aggressive way of dealing with us, or they're putting either direct pressure on us or just somehow convincing us that we have to do something. And I'm sure for some people that's really hard to deal with.
Yeah. It's stressful. And, I think for older adults, especially if you don't understand English very well, if you're not very comfortable with English, you know, sometimes I speak to people who, when they're describing these situations, they tell me they felt embarrassed, or they didn't want to appear stupid
Mm-hmm.
or anything in front of these salespeople. And they just end up getting kind of peer pressured into purchasing something that they didn't
Yeah.
intend to buy. So one thing to just keep in mind, something that we do see a lot in Imperial County, is the fact that if a transaction is negotiated in Spanish or another foreign language,
Mm-hmm.
but the actual written contract is provided only in English and it does not also have a Spanish translation, then the consumer is actually allowed to void
Hmm.
the contract. So that's something we see a lot in Imperial County.
You mentioned consumers sometimes feeling embarrassment or salespeople using that as a tool, like
Yeah,
trying
yeah.
to put pressure on people
Mhm.
and making them feel like if they don't buy it, there's giving them some negative emotion related to not buying something. But I think that's also something that is relevant when it comes to elder abuse cases, like financial elder abuse cases where people don't report because they're embarrassed. And scammers
Yeah.
they're aware of that, and that's part of what their tools are. Like embarrassment is one of the tools that they have, so that they can basically steal from someone, and the senior may then feel too embarrassed to disclose to the police or to their families or to their friends that they gave away whatever $1,000, $10,000 or whatever it is. So yeah, I think that's something that we just have to kind of be aware of, that embarrassment can be used as a tool.
Embarrassment and fear as
Mm-hmm.
well. You know, a lot of these scams, they start with maybe a threat, pretending to be a tax collector or someone from Social Security
Mm-hmm.
or some kind of other authority figure, maybe the police. You know, we've had people tell us that they had Lena Khan from the FTC call them.
Mm.
You know, so it's there. You're right. The scammer's goal is to try to throw you off your feet and trying to make you not think, trying to get you to think illogically. So just always take a beat, pause, call a friend, ask someone if they think this seems normal or reasonable to them, and you don't have to make a decision unless you have thought about it thoroughly.
Are there any cases that come to mind that you would like to discuss, or sort of any big elder abuse situation that you think might be of interest?
So a scenario that I see pretty frequently, that I've seen a lot of actually, is where a owner of an apartment building sells the apartment building to a new owner. And when that new owner takes control and is managing all of the units, they may implement a large rent increase across the board without taking um, care or notice of the Tenant Protection Act, which does provide tenants protections to unreasonable rent increases.
Mm-hmm.
A lot of the older population are on fixed incomes that are not keeping up with this ever increasing cost of living
Yeah.
in this country. And those rent increases can be very impactful and harmful economically. So if you are in that kind of situation, it may very well be that the new owner is just not aware of what the law is. If you find yourself having a large and unreasonable increase to your rent, you can come to our office, make an appointment with us, and we can go over it with you and let you know whether or not it's a lawful increase to your rent or not.
Mm-hmm. Can you say something a little more about the eviction process and what the protections are that tenants have in California?
Yeah, so when people come to our office, I think there's a misconception on what the process is. The eviction process always starts with a notice. So in order for a landlord to evict a tenant, they first need to provide the tenant with written notice. This can be a 3-day notice to pay rent or quit, a 3-day notice to cure or quit if you're violating a portion of your lease, a 30-day notice of terminating the tenancy, or a 60-day notice, depending on whether or not you've lived in the property for a year or more.
Oh, so it goes from 30 to 60 days if you've been there for a year?
Yes. So if you're in a month-to-month tenancy,
Mm-hmm.
and you've lived in the property for less than a year, the landlord can provide you with a 30-day notice to terminate the tenancy. If you've been there longer than 12 months, then the landlord can provide you with a 60-day notice, or they must provide you with a 60-day notice. Since 2020, since the legislature enacted the Tenant Protection Act, there are most tenancies in California require the landlord to provide a just cause reason for terminating the tenancy.
Mm.
So if your property is protected, or if your tenancy is protected by the Tenant Protection Act, then the landlord must provide a just cause reason in the written notice stating why your tenancy is being terminated. So again, the very first thing that will happen if the landlord is trying to terminate the tenancy is provide you with this written notice. When you get this notice, don't throw it away. Don't rip it up in anger. We've seen that.
What about crumpling it into a ball?
As long as you can uncrumple it and read it.
Okay.
Because you want to keep it, okay? Take a picture of it. It's very important that you keep this because any unlawful detainer lawsuit that the landlord files to try to end your tenancy is going to be based off of this written notice. Okay. So after you've made a copy of the notice or taken a picture of it, what I would recommend you do is to write down how you got the notice. Because an important aspect of whether or not a landlord is allowed to terminate your tenancy is dependent on how you actually were served the notice. So take note of, while it's still fresh in your memory, how you got the notice. Did you get it in person? Did you get it in the mail? Was it also posted? How many did you get? Okay, so write this down. Afterwards, same day preferably that you get the notice, call a lawyer or call a legal aid organization. If you're in Imperial County, you can call Elder Law Advocacy if you're 60 and up, and or you can call CRLA as well. Any attorney that helps you look at this notice, they're going to make sure that the notice has all the proper requirements for terminating the tenancy. So there's certain information that by law the notice has to have. And I touched on this a little bit earlier. It has to be served in the proper method as well. So if all of that was done correctly, sometimes it's not done correctly and landlords move forward the next step anyways, but assuming all that's done correctly, the next step is to file an actual lawsuit against a tenant. So a landlord will file what's called an unlawful detainer complaint against a tenant. There's around 4 different forms that are required to start an unlawful detainer lawsuit. The main one's called a UD 100. So you'll get that, and you'll get another form called an SUM 130, which is a summons. And the summons will have some information on what you should do. But I'll go over some basic information. So if you are asserted of a complaint and summons, then that means you already got a notice. You have 10 days to respond to the lawsuit. And in order to respond to the lawsuit, you have to do so in the proper method. So you can't respond by simply mailing a letter to the landlord or to the landlord's legal counsel. You have to file either an answer or some kind of motion in court to respond to the complaint. So if you file an answer, or if you need help filing an answer, you can go to one of the legal aid organizations in Imperial County. You can contact us at Elder Law Advocacy, and we can help you fill out the answer form, or you can go to CRLA. When you file your answer, you'll list different defenses to try to defend yourself against allegations made in the complaint. You can bring up defenses attacking the validity of how you were served with the notice. If the complaint is alleging you owe rent, but there were habitability issues, you can raise those in your answer. And after you filed your answer and provided a copy of your answer to the landlord and the legal counsel, there will be a trial scheduled. So usually a trial will be held a month after the plaintiff in the lawsuit requests one. And at that trial, a judge will make a decision on whether or not the landlord has done enough to prove that they followed the legal process for evicting the tenant and that there's no defenses available to justify allowing the tenant to stay. If you're a tenant and you lose the case, the landlord will file some additional paperwork and you will get a notice to vacate from the sheriff, and you may have only 5 days to leave. You want to try your best to avoid a judgment because that will go on your record and that can really impact your ability to find new housing in the future. It is very difficult to find housing in Imperial County right now. A lot of people that I talk to they spend months trying to find a new place to live. And despite what you might imagine, it's actually quite expensive too. So I would say try to be realistic when you do get sort of a notice or a complaint and summons. There's more than one way to, in a lawsuit, there's no winners or losers. Everyone loses, right? In some sense. You just need to try to find a solution that works for you, that ensures that you have a safe place to stay or a path to move forward to keep yourself safe.
Okay. So just in terms of the timeline, if say you're given a 30 or 60-day notice, if you go through that whole process, the unlawful detainer gets filed if you don't leave, say at the end of that 30 or 60-day notice period, there's an unlawful detainer filed. It takes about a month to get a court date, or is it quicker than that?
I think it's so if a landlord requests a trial, I believe they can get a trial date within 21 days.
Okay, 21 days.
So I say about a month, just
okay,
for a little extra padding.
Okay, and then they have the hearing, and the judge immediately makes a decision in terms of whether the landlord.
The judge will most likely make a decision at the trial about whether or not the landlord has done enough to prove that they should have the right to possession of the property.
Okay.
Yeah, so it's as far as a lawsuit goes, it moves rather quickly, and tenants don't have a lot of time to respond to the notice or the lawsuit, really. It's better now than it was before. Prior to this calendar year, tenants only had 5 court days to respond to a summons and complaint. Now you have 10.
Oh, that's new?
Yeah, that's new as of this calendar year, 2026.
Oh, wow.
So when you get a summons and complaint, you have 5 business days to respond. You don't count weekends and you don't count holidays that the court recognizes. And the first day is the next day after you receive the summons and complaint.
Okay. And then if you go through that whole process and the judge finds in favor of the landlord, you're given 5 days to vacate, and if you don't vacate, then someone eventually will come and remove you. How does that part work?
Well, so the sheriff will come and place a notice to vacate on your property.
Okay.
You'll have around 5 days. You will have 5 days to vacate the property. And if you don't vacate within those 5 days, then you can be locked out.
Okay. And then, but as you said, that's not a good option because then it's on your record and you're going to have problems with that for a long time.
Yeah, no, it's not a good option. Look, I think most issues can be resolved. There's more than one way to skin a cat. And you ultimately, you need to look out for your best interest. And, one thing I like to try to tell clients when we're helping them with a problem is to, yes, there is the legal answer, right? The legal analysis, the kind of black and white legal analysis that we can give them. And then there's just certain economic realities as well and life realities that are good to consider. Take both into account, and they do interact with each other, obviously, the legal analysis and maybe the more economic analysis. But it's good try to consider all factors and all kinds of solutions to resolving your issue, right? It's kind of like when we were talking about the differences between San Diego and Imperial County. You know, issues affecting older adults, they're interdisciplinary. It's not just,
Yeah.
one organization, one legal aid organization is not going to be able to resolve every problem. Sometimes you need help from other organizations as well. We work with a lot of other types of organizations that provide different services that are not legal aid organizations. So if someone comes to us with a specific problem, they may have a legal issue, but they may also have, there might be other aspects to their problem that would be better served in different ways as well. So we try to keep an open mind and just try to offer, talk to people about their problem openly and try to, I guess, work with them to try to understand if there's another kind of way to resolve their problem.
Right. So if someone comes to you and they've received a notice of some kind, like a 3-day notice, 30-day notice, to vacate, you're not just advising them about how the court system works. You're trying to find a solution that is optimal for them. So it may not even, you might be talking about other things. So what are the types of ways you would talk to a client if they came to you with that kind of situation?
Well, I think the way I do it is I like to explain the law first. Okay, so if a client comes with a housing issue, maybe they've received a 60-day notice. I like to explain what are the requirements for a 60-day notice. And I'll try to show them maybe why the 60-day notice they received is not compliant with the law.
Mm-hmm.
I'll then try to give them an analysis of their situation, right? If you get a notice, the integrity of your landlord-tenant relationship is fractured in some way, and they don't want you there, right? Depending on your situation, you may or may not be able to continue to reasonably expect to live in this building or have this kind of tenancy long term. But what you can do is try to assert your rights to delay your eviction, right? The landlord can't force you to leave when the landlord wants. You're not on the landlord's timetable. The landlord has to follow the law, right? And the law's there to give the tenant protection and to also ensure a reasonable move out as well. So not every tenant's going to be able realistically to stay in their current situation, but you can assert your rights in a certain way that makes it easier for you to move out in a way that works for you, where you're not rushed and where you're able to have time to find a new place to live.
Do you ever contact landlords and just kind of talk to them about the situation, see if there's maybe a misunderstanding or maybe just a failure to communicate?
Yeah, that happens across the board a lot. The way I like to work, I like to talk on the phone a lot. I know some people prefer email and letters, and I do that as well. But I really like talking to adverse parties on the phone. I find it very effective. And a lot of times, a lot of issues derive from miscommunication or a misunderstanding. And Most people don't want problems. Most people do want to follow the rules. Um, so I find talking on the phone a good way to just kind of reason with people, to get to know them a little bit better as well. And it's just much faster as well.
Yeah.
So I've had a lot of interesting and funny conversations with adverse parties, and able to work. I've been able to work out a lot of issues that way, just
Yeah.
talking on the phone.
Yeah. I had the same experience. Like, just sometimes, some people are better communicators than others, and sometimes there's just a personality difference, and having a neutral third party get involved who can be very calm and objective about the situation can often lead to a better outcome.
Yeah, and our jobs are not to, um, you know, when I call people, our jobs are not to be bullies. You know, I try to be a voice of reason.
Mm-hmm.
You know, uh, usually when a client is having an issue, it's very it's something that causes them a lot of stress. That's why they called us in the first place, because they can't or don't want to deal with this problem. So, um, I do see it as part of our job to um, be a very not neutral. We're advocating for our client, but to do so in a way that is peaceful,
Mm-hmm.
very reasonable, strong at the same time. Um, let's see. One thing that I thought was funny that I heard another lawyer say that I always tried to, I'm not really sure what he meant by this, but I've tried to implement it.
Mm-hmm.
It's better to be a pickpocket than a mugger. And
Okay.
so when I'm calling people or trying to exact information from someone, um, yeah, I'm not doing it in an aggressive way.
Okay. Um, I wanted to touch on power of attorney. Can you just describe what that is and the kinds of powers of attorney that we prepare, and how they how they're important for people to have?
Yeah. So when you give someone else power of attorney, what that means is that you are giving them the authority to make decisions on your behalf. So when you give someone power of attorney, you can give anyone power of attorney. It doesn't have to be a lawyer.
Mm-hmm.
Okay. Some people think if you want to give someone power of attorney, they need to be an attorney. That's not the case. Power of attorney just means that you're giving someone else the authority to make decisions on your behalf. So there's a few different types of documents that we make for our clients if they want other individuals to have the authority to make decisions on their behalf. There's an advanced healthcare directive, and there's a financial power of attorney document. So in California, if you would like someone else to make decisions on your behalf, if you lose the ability to make your own decisions, whether that be through um, dementia or some kind of other medical condition, then you will need to have a advanced healthcare directive in place. And in an advanced healthcare directive, you have the ability to name a third person as your agent to have the authority to make medical decisions on your behalf. You can also make certain selections in your advanced healthcare directive that gives your healthcare providers and your agents instructions on what kind of care you would like to receive. So for example, if you would like to donate organs after you've passed away, you can make that kind of selection in your advanced healthcare directive. You can be as specific or as broad as you want. If you only want to donate specific kinds of organs, you can specify that in your advanced healthcare directive. If you only want your donations to be used for therapeutic reasons or educational purposes, you can be specific as well. And then on the financial power of attorney side, this document is for financial and legal decisions. So if you would like someone else to make financial or legal decisions for you in the future, if you are one day unable to do so for yourself, then you should also create a power of attorney document, a financial power of attorney document. And in this document, you can give your agents, your third party, the authority to make any kind of financial and legal decision for you, or you can only grant them the authority to make very specific types of decisions. So these documents, they can be as broad as you want them to be, or as narrow as you want them to be. But essentially, if you want any of your loved ones, people that you trust, to have the authority to make medical or financial decisions for you, then you should make these documents while you're healthy and while you have the ability to make your own decisions. Because if you lose the mental capacity to make your own decisions, you will not be able to create these documents. And unfortunately, your loved ones, your spouse, your children, they can't make these documents on your behalf. So I encourage anyone who's interested in having these documents not to wait, because you don't know what can happen in the future.
What happens if someone gets sick or is in an accident and they don't have these kinds of documents? How do the decisions get made?
Well, look, it depends what kind of decisions you want to make. Okay. A lot of our clients, their only sources of income and their really only financial asset is money that comes from Social Security. If that's the case, you can, and if the individual does not own any real property as well, if that's the case, then your loved ones can contact Social Security and they can apply to become a representative payee. And they will have the authority to manage your Social Security income. That's a great way to make sure that the incapacitated person's finances are handled without having to get a conservatorship through the court.
Which is what? What's a conservatorship?
So a conservatorship is it's a court monitored process where a judge. So if someone's incapacitated and their family member or one of their loved ones would like the authority to make decisions on their behalf.
If they don't have a power of attorney.
They don't have a power of attorney or advanced healthcare directive. And if they want to make decisions related to the person's house, right, or very specific medical decisions, then they'll need to petition the court to actually get the authority to make decisions on the other person's behalf, on the incapacitated person's behalf. So they file a series of documents. One of the documents has to be signed by the incapacitated person's doctor or medical provider declaring that they are incapacitated. A court investigator will be assigned from the judge. This investigator will interview the proposed conservatee and the proposed conservator and the family just to make sure that it's a safe situation and to gather information about whether it's in the proposed conservatee's best interest to be under a conservatorship. The proposed conservator will gather evidence to try to prove why it is in the best interest of the conservatee to be under a conservatorship. And the conservatee will also be assigned an attorney to make sure that their rights are being protected. If the conservatee can express their displeasure to the conservatorship, to the proposed conservatorship, then this attorney will defend their rights to not be under the conservatorship. There will be a court hearing where the judge will take into consideration the information provided by the investigator, the evidence provided by both sides, the proposed conservator and proposed conservatee. And if the judge determines that a conservatorship is in the proposed conservatee's best interest, then he'll grant or she will grant the conservatorship. Conservatorships are a la carte in terms of what kind of decisions you will be granted to have the authority to make for the conservatee. So if you want to get a petition for a conservatorship over your loved one, you will need to be specific in your petition about what kind of decisions you're trying to make for this person. And if the judge does determine that it's in the conservatee's best interest, they'll grant the conservatorship and they'll issue letters of conservatorship, which is basically just the order from the court detailing that the conservator has the authority to make specific types of decisions for the conservatee.
Okay,
That
that's
was
I think your description of conservatorship is a great way of expressing why people should get powers of attorney, because the chasm between what it takes to get a power of attorney in place and what it takes to get a conservatorship in place is just enormous.
Yeah, you don't want to do it.
Yeah, right,
Or
exactly.
you don't want to put your family through that. Yeah,
Exactly. So, it's really just you're doing everyone a favor if you do that basic estate planning, get the powers of attorney in place so that nobody has to go through that process you just described.
yeah. Well, none of us think or really can imagine being in a state where you can't make your own decisions. But our brains do change as we get older. And you don't know if you could get in an accident or if you can be struck by some kind of other illness that makes it difficult for you to make your own decisions. And your loved ones are going to want to take care of you. They're not going to just abandon you. They're going to want to do everything they can to make sure that you're healthy and that your needs are being met. So by creating these documents, you do save them a lot of not just headache, but a lot of heartache as well, because it's not no one wants to go to court. Again, a lot of lawyers don't even want to go to court. No one wants to go to court, and it can also be expensive.
Mm-hmm.
You know, the legal cost if you hire an attorney to help you for conservatorship, can be around $10,000 sometimes. So
yeah, and for conservatorship, there's conservatorship of the estate and conservatorship of the person that sort of correspond to the financial power of attorney and the healthcare directive. But for the conservatorship of the estate, there's annual reporting that's required as well. So after you go through that whole process, you then every year you have to report.
Exactly. Yeah, you have to keep a ledger of what money from the conservatee you've used to buy food or medicine for the conservatee. And yeah, it can be, like you said, a big headache, a big hassle for the conservator.
Yeah. I want to wrap up our conversation. Is there anything else you want to say about your practice, about what you've experienced?
No, I would just, if you have any kind of issue and you're 60 and up, maybe someone is making you feel uncomfortable. If you have a problem with your landlord, if your rent's been increased, if you have appliances or other problems of your property that your landlord is refusing to fix, if you have credit card debt that you can't pay off, if you've been sued for credit card debt, or even if you have an issue that you're not sure if it's a legal issue, I would just encourage you to call us and we'll talk to you about your issue. And if we can't directly help you, we'll at least try to give you information or a referral to help you get the help that you need. So don't hesitate in contacting us.
Mm-hmm. And so they can call or they can do so on our website to...
They can do so on the website or they can call us. If you call, leave a voicemail and we'll get back to you as soon as we can.
Okay, great. Thank you very much, Alan. We are very happy that you're part of our legal team. You're very effective, and I think you've talked about a number of approaches you have to helping clients, and that really does help you help them. So we appreciate you very much.
No problem. Yeah.